When a lawyer drafts a complaint and files it with the court, the facts on that paper are rarely final. Investigations uncover new details, initial legal theories collapse, and entire paragraphs often need to be rewritten or slashed entirely. The first draft of a lawsuit is inherently fragile. To correct these inevitable initial miscalculations, litigators rely on Rule 10 of the Rules of Civil Procedure. This rule provides the mechanical framework for altering the pleadings, forcing the court to balance the necessity of finding the objective truth against the strict deadlines required to keep the judicial system moving. We are going to forensically map Sections 1 through 8 of the 2019 Amended Rules of Civil Procedure. We will pinpoint the exact procedural boundary where a lawyer's absolute right to rewrite their case evaporates and strict judicial scrutiny takes over. The 2019 amendments removed the leniency that used to protect litigators. Under the current framework, a single misstep regarding when and how to amend a pleading will result in waived defenses or an immediate dismissal of the case. Section 1 establishes the baseline mandate for the entire rule. The court's primary objective is to determine the actual merits of a controversy. To achieve this, the rules actively instruct judges to disregard minor procedural technicalities if allowing an amendment will resolve the dispute faster. The mechanics of a general amendment are straightforward. A litigator can alter a pleading by adding or striking out an allegation, correcting a mistake in a party's name, or fixing an inadequate description. There is a hard limit to this leniency. If the court determines the amendment is being deployed maliciously to drag out the litigation or subvert the rules, the judge will reject the application entirely. A filed pleading is not locked in carbon. The law actively encourages lawyers to refine their documents if those edits bring the court closer to the true facts of the dispute. Section 1 acts as a shield for practitioners. When facing a borderline procedural challenge from opposing counsel, citing this mandate of liberal application is the most effective way to secure an amendment and avoid having to file an entirely separate lawsuit to correct a mistake. This timeline tracks the life cycle of a pleading. Under Section 2, the absolute freedom to amend lasts only until you hit a strict procedural barrier, the filing of a responsive pleading by the opposing party. As long as you are inside this green zone, you may amend your pleading once as a matter of right. You do not need the judge's permission. For a standard complaint, this window closes the moment the answer is filed. If you are amending a reply, you have exactly 10 calendar days after serving it. Opposing counsel will often try to kill a case early by filing a motion to dismiss instead of an answer. Because a motion to dismiss is legally classified as a motion, not a responsive pleading, it does not close the window. The plaintiff retains full, absolute authority to amend their complaint and fix whatever defect the defense just pointed out. The moment the defendant files their answer, that absolute right evaporates. The vault slams shut. To make any substantial amendment from this point forward, you trigger Section 3, which requires explicit leave of court. Obtaining leave of court requires formal friction. You must draft a written motion, provide notice to the adverse party, and give them a legal opportunity to argue against your requested changes in a hearing. The 2019 amendments introduced lethal restrictions here. A judge is now strictly required to refuse your amendment if it is designed to delay the trial, confer jurisdiction on a court that doesn't have it, or retroactively cure a complaint that lacked a valid cause of action from the beginning. You cannot breathe life into a case that was dead on arrival. The filing of a responsive pleading is the ultimate pivot point in civil procedure. It instantly transfers control of the document's evolution away from the lawyer who drafted it, placing it entirely under the strict discretion of the judge. Not hearing. Under Section 4, the court prioritizes efficiency over bureaucracy when dealing with harmless mistakes.
If the defect is merely a misspelled name, an incorrect party designation, or a clear typographical error, the judge can correct it summarily on the spot. They can do this on their own initiative at any stage of the action, provided the correction doesn't prejudice the opposing party. The leniency for typos entirely disappears when the case reaches the trial phase. Under Section 5, we encounter the doctrine of implied consent, which governs what happens when trial testimony strays outside the boundaries of the written pleadings. If a witness introduces facts about an unpleaded issue and the opposing counsel fails to object, the law interprets that silence as implied consent. The pleadings are automatically deemed expanded to include the new issue, requiring no formal motion to amend. This logic tree illustrates a severe 2019 rule change. Previously, if opposing counsel objected to surprise evidence, the judge could pause the trial and allow the pleadings to be amended to fit the new testimony. That is no longer true. Under the current rules, if an objection is raised, the amendment is strictly blocked and the evidence is excluded. During trial, a litigator's silence is legal consent. Policing the introduction of unpleaded evidence in real time is just as critical to the case's survival as drafting the initial complaint accurately. We must draw a hard line between fixing the past and adding to the future. An amended pleading corrects facts that already existed when the case was filed. Section 6 introduces the supplemental pleading, which sets a new document right next to the original to capture events that happened after the lawsuit began. Supplemental pleadings are never a matter of right. They always require a motion and leave of court, and the defense gets 10 days to respond. Crucially, a supplemental pleading cannot fix a premature lawsuit. It can only add new chapters to a valid existing claim. When making these changes, Section 7 imposes a strict administrative protocol. You cannot file a single page containing only your new paragraphs. To prevent confusion in the court records, you must file a completely new copy of the entire pleading with the amendments clearly marked. This requirement exists because of Section 8, which dictates the obliteration effect. When an amended pleading is admitted, it entirely supersedes the original document. The first draft legally ceases to exist as an act of pleading. The penalty for poor drafting here is absolute. Any claim or defense written in the original pleading that you fail to copy into the amended version is legally deemed waived. In this diagram, you can see the evidentiary consequence of this erasure.
Any damaging admission your opponent made in their first pleading loses its status as an automatic judicial admission once the document is superseded. It is downgraded to an extrajudicial admission. Amending a pleading wipes the judicial slate clean. If you want to use the secrets your opponent confessed in their dead original pleading, you must formally offer that document back into evidence. Rule 10 isolates the exact moments where legal strategy intersects with administrative reality. It tests a litigator's foresight, demanding that they predict the trajectory of the facts before the trial even begins. The structure of the rule dictates a stark transition. You begin with the absolute right to shape the narrative, but the moment the responsive pleading is filed, you are operating entirely on judicial discretion. The 2019 amendments removed the safety nets. You can no longer rely on a late amendment to cure a missing cause of action, manufacture court jurisdiction, or bypass an objection to unpleaded evidence during a live hearing. Civil procedure is the physical environment where legal logic operates. The rules governing how and when a document can be altered determine whether the merits of the dispute ever see the light of day, or if they are executed on a deadline. Mastering the timelines, the judicial gates, and the evidentiary consequences of Rule 10 ensures that when a case reaches its conclusion, it is decided on the weight of its facts and not lost to a technical misstep.